Hello, everyone. It's your friend Rick. It is Thursday, July the 6th, 2017. If you need to contact me because you're interested in making a donation in which I will provide you a gift of these affidavits for which you can look at them, restructure them, read them. By reading them, you're going to learn a lot. Uh, and use them to fit your situation. I provided instructions of how to use them, what to put in them, and I provide a lot of PDFs from, like this right here. This could be a PDF. Well, let me give you my name. It's rick0327 at me.com. That's my email address. So what we do here, you got this page here. Let's say we want to make this page right here. We had Hoke versus Henderson, a very, very important case law that I'm going to be discussing in a little bit. So you go over to File, and you click on Export as PDF. Right? Export as PDF. There we go. And you can save it on your desktop. Up here you can reword it, any way you like it. You click save, and that's it. You have it. And that's what I've done. I've created a lot of PDFs that I feel are very informed. It will keep you informed, and you could also use them to cut and paste, add to the documents, the affidavits that I provided you. Okay, so why is Hokie versus Henderson very, very important for us? Well, we've discussed that we are demanding a trial by jury. And why are we demanding a trial by jury? Okay. Well, we're doing it because it's our right, right? And when you have a right guaranteed in the Constitution, in the Bill of Rights, and they do not follow this demand, well, the judge or fake judge is placing him or herself in jeopardy of losing their presumption of judicial immunity, because they're going to be knowingly acting without jurisdiction because you demanded a trial by jury for a controversy of $20 or more. I've looked it up, and there's no reason. The only way they could take it away from you is if they have a state law where, like child support, where they don't hold juries. You know why? Why don't they do that? Remember, I discussed it in my car the other day. The expedited judicial processes, in subsection C it says, but it must be in accordance with due process. Okay, well, due process is synonymous with the law of the land. Okay, but due process guarantees us a trial by jury. So let me show you here why it's important. Okay, one more. I got it. All right. The law of the land in bills of rights does not mean merely an act of the legislature, for that would abrogate all restraints upon legislative authority. The clause means that the statute, right, what we just discussed, a state law that deprives us of a right, statute which deprives a citizen of rights of person and property without a regular trial. There we go. According to the course and usage of common law, would not be the law of the land in the sense of the word. I don't know what the rest of it says, and I'm not even going to try and find it because I don't want to embarrass myself in front of all of you. But what that means is a judgment not from a jury trial by jury is not in accordance with due process. So what does that mean? It means it's void. Okay, so we have all of these judgments issued by judges, by fake judges, non-judicial persons, and because they're all in on the scam, they're all enforcing these judgments. So what we got to do is we have to force them to void them out. Now, how do we do that? Well, we have to stop them from issuing it without a trial by jury. So you're getting ready. You got this letter in the mail where they scare the shit out of you that you got to show up. You have to bring all your financial information, but if you don't show up, you may be incarcerated. If you don't show up, they don't say may. If you don't show up, they will issue a default judgment against you. If you don't show up, your driver's license may be suspended, which is against the Supreme Court, Stinney versus Holcomb, where it says that a privilege cannot be taken away from you without what? Without due process. Okay, and what is due process? Trial by jury. Due process is synonymous with the law of the land. Okay, so we have to get them from the very beginning to start demanding a trial by jury. Darren, one of my subs in Pennsylvania, he has his arrogant judge denying him on paper in a response to his demand for a trial by jury, denying him his Seventh Amendment right. Then, what else did he do? Oh, he said federal rules do not apply in state courts. This guy is a comedian. Okay? Now, every state has the equivalent. So let's just say you don't want to, this guy's, obviously this clown, this judge. Now, Darren, you got to be watching this video. This is what I want you to do. I want you to go into Pennsylvania Constitution, and you're going to look for the Constitution equivalent for trial by jury. All right? Let me show you real quickly how I do it in New York. Okay? Hold on. Constitution, State of New York. Okay? Bill of Rights. Article 1, Bill of Rights. Trial by jury. How waived? Do you see anything where it says when it can be denied? Hold on. No, how waived. That means you have to waive. We have to waive it. So, by us submitting this, we're not waiving it. We're telling them we're demanding it. So, everybody who has this, what I want you to do is, when you have this, look in your state constitution, right, and add it over here. Okay? Seventh Amendment for controversy of more than $20. Then under there, you can move the supremacy clause down. What the supremacy clause is every judge and the courts are bound to act in the pursuance, meaning they must be forcing everybody, that means the prosecutor, the defendant's attorney, everybody there, jury, to act in the pursuance of the Constitution. If anybody in that room is straying from the Constitution, it is the duty of that judge to bring them in line. You understand? But we know they don't. Okay, but here, I'm just giving you an example. New York State, right there, trial by jury. It's right there. So, let me show you real fast. Trial by jury in all cases in which it has heretofore been guaranteed by the constitutional provision shall remain inviolate forever. Inviolate forever. That means they can't take it from you. But a jury trial may be waived. You may waive it in all civil cases in the manner to be prescribed by law. So that means we have to waive it. They can't take that from us. So that also means they can't create a law to take it away from us. Because why? It shall remain inviolate forever. Okay? And we have this constitutional amendment called the 14th Amendment, which says that the state is not allowed to create a law which deprives us of our constitutional guarantees. Now, why was that 14th Amendment made? Well, real quickly, a lot of people believe it made us slaves. Well, what it was because the 13th Amendment, after the Civil War, the slaves were freed, but what happened was the states were creating their own laws. And they were denying the federal Constitution. Okay? And what happened was they had to make a constitutional amendment. It's very difficult to get a constitutional amendment. Okay? I mean, they're trying all the time to take away our Second Amendment all the time. All right? So, let's just move away from this now. I made my point. Okay. Right to a jury trial in civil actions. Okay. Federal Constitution guarantees. No maybes there. The guarantee is, that's it. The right to a jury trial in civil actions in federal courts. And nearly every state constitution contains a similar guarantee. Right? Citation 2. Let's look down here. C. California Constitution, Article 1. Now, this is Gonzaga. Gonzaga is is this Gonzaga? Or whatever. He's given an example of the California Constitution. He could have shown the New York Constitution, Article 1, Section 2. Okay? I just, before I even showed you this, I showed you. Okay? So, we know we're guaranteed. That's why we must force them to do it. That's why this is very important here. This is why I made it. This is why you have to, when you're in there, with so many things you have to object to. Objection. Clarification of the evidence introduced by the petitioner, plaintiff, that my conduct caused pain and suffering from an injury in fact, which is a constitutional minimum standard as set forth by the Supreme Court of the United States. What we do is I spell it, it's an abbreviation, SCOTUS, SCOTUS. So if you see that in my paperwork, I finally figured out to start using that. Okay, I'm thick-headed. But now, one of my subs told me, Rick, you got to check out 28 U.S.C. Section 2072, which states that the courts must follow the procedures set forth by the Supreme Court. Because what the Supreme Court is the number one court in the land. So they just said that there's a minimum standard that the courts must meet. So when a plaintiff brings forth a claim, that claim must show an injury in fact caused by your conduct. So how did this happen? How did your conduct of allegedly not paying child support cause an injury to the baby mama? How? Remember I said it in my car? How are they going to prove that? They can't. They cannot. Now, also by doing this, objection, the undersigned demands 7th Amendment guarantee to trial by jury, whereby a judgment issued without trial by jury is void, for it is not in accordance with the law of the land, which is synonymous with due process. So we got this judicial actor having to act in pursuance, right, because of the Supremacy Clause, Article 6, Section 2. Now, if this clown does not do this, the next move is a writ of mandamus, writ of prohibition, and then higher court. But we got to get this in the court first. Now, I read this before. Law of the land. The term in a constitutional provision that no person ought to be taken, imprisoned, or divested of his freehold, liberty, or privileges, or outlawed or exiled, or in any manner deprived of his life, liberty, or property, but by the law of the land, is synonymous with due process. That's it, but guys, you got it. It's very hard to argue with this. You got it? So any judgment issued without a trial by jury is void. There we go. Now, remember, I like to threaten the judges in my paperwork. A judicial act of depriving the undersigned of a constitutional right to trial by jury is knowingly acting without jurisdiction. Therefore, forfeits the presumption of absolute judicial immunity and can be held personally liable for damages for conduct causing the undersigned an injury in fact. The undersigned understands that any state statute or law claiming that a trial by jury is not required in any controversy over $20 is a clear violation of the 14th Amendment and an attempt to deprive the undersigned of a right guaranteed in the Bill of Rights. Further, the judge or non-judicial person presiding is knowingly acting without jurisdiction and forfeits any presumption of judicial immunity. It is understood by the undersigned that courts and officers of the court are to remain impartial and protect against deprivation of rights guaranteed in the Bill of Rights. Okay, that's about enough. That's all you need to see. But now you understand why it's important to demand a trial by jury. Okay? We have to get them from the very beginning. And what we're also doing is we're letting the judge know that we know what the hell is going on. That we're not just some simple fool that you're just going to talk over. Because you know what we're going to do? You don't even have to talk once we... That's why I have... what I've done now is I have the affidavits packaged in such a way that I'm telling you, listen, your upcoming hearing, I want you to submit this, I want you to submit that, I want you to submit this, I want you to submit that, and that's it. That way when you go there, you just can stand there with your hands at your side, and when some scumbag judge or fake judge is going to try and trip you up, all you need to say is, sir, ma'am, I'm relying upon my paperwork, and I'm confident that you're going to reach a just decision based upon my paperwork before you. That's it. You know, something real simple. I rest on my paperwork. That's it. No reason to talk. Are you sure? Yeah, I'm sure. You sure you don't need an attorney? No, I'm sure. You know, that's it. Okay? If you're on my channel, you're getting good advice. Okay? And let me say this. Yeah, I ask for a donation. I don't ask for anywhere near what anybody else is asking. But here's another thing I give you guys. I'm giving you free knowledge. I don't do a quick 5-minute video, 6-minute video as an advertisement. So you come to so you email me, and then I hammer you, as a couple of channels do. Okay? I'm giving you sound advice. Even if you don't donate a penny to me, I've given you enough knowledge that you can go into a court and protect yourself. One guy emailed me the other day, or today as a matter of fact, And he forwarded me a document. I go, did you donate? He goes, no. He goes, I copied it from the channel. All right, no problem. I have no problem with that. If I put it here, it's all yours. If you want to take this and freeze it and copy this down, go right ahead. I don't have a problem with that. But you're going to need the rest of the stuff. But I don't have a problem with it. Okay, I know a lot of you are, in financial straits, and I've helped a few people out. But I got to be careful too, because there's always a couple of idiots that ruin it for everybody, like Mr. Sean Bowens or Mr. Vincent Ross. Okay, two schemers that they take advantage of somebody's kindness. But because I'm a good guy and I believe in karma, I've sent out many of my affidavits free of charge. Okay, I don't do it all the time, but I've done it enough. And people out there, you know that I'm right. Those of you that Oh, here's another thing, guys. Please, just keep the emails brief. Okay, I mean, I know your story is important to you, and I don't mean to minimize it, but if you could keep it to a couple of paragraphs, it really would make my life easier, and then I can focus in on if I can help you out in any way. Okay, so I hope I've explained to you guys why it's important to demand your right to a trial by jury. And remember, I don't care what they say. We don't do that in family court. We don't do that in whatever the court is where you live, in child support. Then you got to say, well, then you're in violation of the Constitution. And then it's on the record that you're objecting. And if you notice here, notice of demand, objection. Notice of demand, no motion. You see me motion? I don't motion. I don't ask permission of these people. I take my knowledge, I give it to you guys, and then you guys take it and you bring it into court, and you're telling them, listen, I know what's going on. That's why I put in my paperwork. It's my belief. I understand. Blah, 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 and that's it. Okay? So I hope I've brightened your Thursday. I hope you learned, why the Seventh Amendment must be brought up from the very beginning. And hey, guys, even if you're halfway through, well, let's say you got a final hearing come up. Say, excuse me, sir, ma'am, did I waive my right to a trial by jury? Well, I am not waiving it. As a matter of fact, I demand it. Well, it's too late. No, it's not too late. And any judgment issue without a trial by jury is void, and you forfeit your immunity. And that's it. All right, guys, enjoy the rest of your day. Till next time. Bye.